executive power comes the Japanese-American cases, and that's what Hirabayashi and Korematsu are about. They too are sweeping executive acts of curfew declaration, of orders to leave the coastal areas of the West Coast, and then of internment. 1, 2, 3. And Congress backs up that executive order with federal criminal law, federal criminal consequences. So when Gordon Hirabayashi violates the curfew, he gets prosecuted, and thus his appeal to the Supreme Court. And when Fred Korematsu violates the exclusion order, he gets prosecuted, and thus his case to the Supreme Court. And the forgotten, and perhaps the most important of the cases, when Mitsuye Endo violates the internment order or challenges it, her case goes up to the Supreme Court too. Here are Jackson's votes and his roles in those cases. Hirabayashi, the curfew case in 1943, is upheld, again, unanimously by the Supreme Court as executive power appropriate in the national security context, given the limited imposition of a curfew. Indoors, 8 p.m. to 6 a.m., not the worst thing a president could do to a person. The president may do so. Jackson, again, behind the scenes, is saying, wait a second, what's it based on? He's drafting. But in the end, he votes with Chief Justice Stone, whose opinion says, thus far and no further. This is only about the curfew. Well, already in the pipe, and a year later adjudicated as an exclusion case, is Fred Korematsu's case. Fred Korematsu didn't violate a curfew. He violated an order to report to a racetrack for processing as a Japanese American that was a way station on the way to the internment camp. Now, a curfew doesn't sound like a small deal to me, but being ordered to leave my home and report to a racetrack for exclusion from a coastal area is a bigger deal. And the Supreme Court, 6-3, one of its most notorious, infamous moments, upholds the exclusion order. The court's opinion says, see Hirabayashi. In national security crisis situations, the president has commander-in-chief, etc., authority to respond to potential threats based on military and intelligence judgments, and liberty must give way. Jackson and the two other dissenters say, hey, wait a minute. What about the thus far and no further part of Hirabayashi? This is exactly what I was agonizing about. In 41, 42, 43, in the Hirabayashi context, Jackson says, this is excessive. This is a liberty violation of the individual. This is beyond enumerated powers of the president. And, by the way, this is racist. This is based on ethnicity, heritage. Fred Korematsu didn't enlist in anything. He didn't choose anything. He was born of Japanese ancestry. The Equal Protection Clause prohibits that as to the states, and as a matter of due process, the national government can't do that kind of stuff, and nothing in executive power trumps that. Jackson's dissenting opinion in Korematsu is a landmark of great, great significance. Every justice to serve on the Supreme Court since World War II has in one place or another said, Hirabayashi, maybe Korematsu wrongly decided. But never has a court, in other words, 5 or more justices in an opinion, said Korematsu is bad law. The thing that says Korematsu is bad law is only 3 dissenting opinions. Owen Roberts, Frank Murphy, and Robert Jackson, in a losing argument in the fall of 1944. Now, one other thing is going on in this pre-Nuremberg period for Jackson at the Supreme Court. He's seeing how judging works, both in himself and in his colleagues. And he's finding it in himself in adjustment. The sort of advocate role, the executive branch temperament and reflex, etc., is where he came from, and he's wrestling with it. That's what those unpublished draft opinions are. He's learning to be a judge and to be independent. He later was asked by Tom Clark, Harry Truman's Attorney General, who was appointed to the court in 1949, how long does it take? And Jackson said, well, I asked Hughes the same question when I came on the court, and Hughes said about 2 years. Jackson told Clark, I think it took me about 4 years. And Clark, you can kind of do the math, but I think 3 years will turn out to be the right number for figuring out Clark's ability to transcend executive reflex and appointment loyalty and be an independent judge. But that's in himself. What Jackson's seeing in a number of his colleagues, to his great dismay, is that some of them aren't even trying. That some of them have an approach that is as partisan as pre-committed, as reflexive as when they served in the executive branch. By 43, the Rutledge appointment, and 44, with the exception of Owen Roberts, this is an entirely Roosevelt-appointed court. Yes, Stone had first been appointed by Coolidge, but elevated by Roosevelt. But among these new dealers, Jackson, I'm summarizing a bit, sees that 2 or 3 or 4 of them continue to wear a New Deal hat in the Supreme Court. And he finds that deeply troubling and inappropriate. Indeed, in particular moments, he sees the most committed of them bullying the softer of them to come out this way and to do these things, to help labor unions, to help the president, to help, etc., interests. And Jackson's quite disgusted by this. It impairs what were very close friendships. They continue to be friendships, but they're damaged friendships or lesser friendships. And it causes Jackson to think of quitting, of leaving the court. Now, a passing thought? No. Job interviews, salary negotiations, law firm retitling agreements all worked out for Jackson to leave the Supreme Court in 1943 because he loved law practice. He was figuring out how to be a judge, but to be part of a court that wasn't very judge-ish wasn't particularly satisfying to him. He was a little itchy. The President of the United States scenario had, of course, bloomed and disappeared. And so what Jackson was prepared to do was move to New York City and be something like John W. Davis for the lawyers among us, the sort of grand poobah of a major Manhattan law firm. Jackson, Simpson, Thatcher is what it would have been called. All worked out down to the draft letterhead. And then Jackson, I think with some serious advising from his very close friends here in Chautauqua County, reconsiders. He also discusses this with Franklin Roosevelt, and he pulls back and decides to stay put. Now that, of course, brings us into the spring of 1945 when the landscape again changes. Now Roosevelt's dead. Now Harry Truman is an unprepared, reluctant president stuck with this enormous job. Now World War II in Europe is almost won. And the big three, Roosevelt, Churchill, Stalin, have a commitment to prosecute the captured Nazis as war criminals, as international criminals. The executive branch, Truman ultimately, once he learns of the Roosevelt planning, delivers on that commitment and recruits Jackson off the Supreme Court to do that job.